Hi, everyone, and thank you so much for coming this morning to our virtual roundtable on reform of executive power with Georgetown's Institute for Constitutional Advocacy and Protection, Checks and Balances, and the Presidential Reform Project. I'm going to start off just by introducing our panelists. Myself, I'm Quinta Jurecic. I am a senior editor at Lawfare, a fellow at the Brookings Institution, and a contributing writer at The Atlantic. And we're very happy to have a wide range of experts to talk with us today. So we have Bob Bauer, who is former White House counsel to President Barack Obama and one of the co-founders of the Presidential Reform Project with Jack Goldsmith, also the former Assistant Attorney General in the Office of Legal Counsel under President George W. Bush. We're also joined by Kelsi Corkran, the director at Georgetown's Institute for Constitutional Advocacy and Protection, also a former Justice Department attorney, Mary McCord, who is the executive director of ICAP, and of course, Alan Charles Raul, who is a former associate counsel to President Reagan and a founding member of Checks and Balances. We have a little bit of an unusual schedule for you today. What we're going to do is have 3 different sessions in this event. So we're going to start with a conversation with Bob and Jack. Then we're going to shift to a conversation with the other 3 panelists. And then in the last 15 minutes, we're gonna sort of all come together for a 15-minute lightning round where everyone can weigh in with their concluding thoughts. So let's start off with a conversation with Bob and Jack, if the other panelists wouldn't mind hopping off, and I'll cue you back on when it's time. Wonderful. So I thought I would start by just setting the groundwork a little bit, and Bob and Jack, giving you an opportunity to talk a little more about the Presidential Reform Project. You're obviously not new to the question of reforming the presidency. You, of course, wrote a book together titled After Trump, which was published in September 2020, about a range of reforms that you felt were necessary to respond to the Trump administration. But the Presidential Reform Project is relatively new. It's only in the last few months or so. So what led you to decide to put together the project now?
Bob, you should answer that.
Our view was that there's a window, not clear how wide the window is, for some action to be taken to implement some of the reforms that we and other people in various forums support to address the problem of the challenge of institutional reform of the presidency. And so we wanted to structure something that would enable us to express our views on this, join the debate actively, beyond publishing the book, in effect, bring it into the debate in a more immediate way. And so we established the Presidential Reform Project. We have a website that enables people to catch up with our latest thinking on these particular issues, and also to learn how we view the priorities that ought to be set for presidential reform, ought to be considered for presidential reform, given that what we propose in the book is wide-ranging, and we would not expect, of course, realistically, that all of the issues that we cover are issues that are going to wind up being successfully addressed in the reform process. So I'd invite Jack to add.
Yeah, Jack, I love your thoughts.
That's basically it. This is just an effort to take, as Bob said, it was a wide-ranging book with over 4 dozen reform proposals, and to create priorities and to try to use this as a mechanism to try to influence the debate through writings, through discussions, through events like this. So we're trying to basically take the proposals in the book and do our bit to turn them into reality. Given the significant hurdles, we still think that there's something that can be done here, and we're trying our best to make it happen.
So let's talk about the hurdles a little bit. You formed the project, or it was announced in early September. Now, of course, it is early November. Time has passed very quickly. How has your assessment of the prospects for reform changed or not changed in the intervening months?
So I'll take a crack at that. Well, we'll talk about last night and the significance of last night at the end of this point. So even by September, it was clear that reform was not a top priority in the Congress, and that some issues were going to be harder than others. And as a general matter, the issues that were more tied to being anti-Trump, and a particular response to Trump had a predictably much lower chance of garnering bipartisan support. But that said, there's actually a lot of reform movement in the Congress right now in various pockets of the issues we talked about and some other issues. And it had become clear by September that some of those were more likely to be possible. Inspector General reform, for example, is moving along. Emergency powers reform I think, has a good chance of garnering bipartisan support. What's happened in the last 2 months is that there's been movement on those issues. There's been a little bit of movement on issues like congressional subpoena authority, but really no movement on issues like, for example, tax disclosure reform, conflict of interest reform, emoluments reform, that are pointed more directly at at Trump's presidency. That just has a harder time garnering bipartisan support. Just about every one of the reforms in our book are somewhere in some bill in Congress or something like what we proposed. But the likely reforms are going to be the ones that are likely to make it through in Congress are the ones it looks like now, and I think especially after last night, are the ones that aren't seen as being particularly directed towards Trump's sins.
So let's talk a little bit about last night then, because I do think that is important context. Obviously, we're speaking, the votes are still being counted in my home state of New Jersey, but it does seem that New Jersey's Democratic governor has eked out a very narrow win. Of course, in Virginia, the Republican candidate won the governor's race, and it seems like Republicans had a pretty strong showing across the board in Virginia and across the country. So, Bob, maybe I'll turn to you first. How does that change or not change how you're thinking about the prospects here?
It will take a few days for this interpretation, inevitably over interpretation of these election results to really, I think, shake out and enable us to see what impact this is going to have. It will certainly have some impact. This morning, the thought that comes to me is simply that it's much harder in an environment like this to move process reform. I think you'll hear some arguing that voters aren't interested in process reform. They've registered some fairly concrete concerns about the conditions under which, or the ways in which we're managing the public health controversy. Other issues, obviously, that came up, including the relationship to the schools and the opening of schools to educate their children during the pandemic. I mean, a whole host of issues of that kind. And so there's going to be a shakeout period here where it's just not clear what can be kept on the agenda as political actors calculate and recalculate what's possible and what's advantageous in the weeks ahead. But process reform is always hard. And particularly in a very polarized polity where every process reform is scoured for the potential that has been designed to help one party over another, that mutual suspicion doesn't help much. And if there is a view that there are some really urgent demands that the voters would like to see met, and particular messages that they would like to see come out of Washington, that may not help very much with the kinds of reform that we're talking about here. I'm not saying it's fatal by any stretch of the imagination. Again, I want to emphasize, I think we have a period of time where there's going to be a lot of analysis and counter-analysis and polling taken and interpretation of the polling data, conflicting interpretation of the polling data. So these assessments are not stable, but in the immediate environment, it's hard to see a development like this being particularly helpful to a multi-pronged, serious reform effort of the kind that we're talking about here that goes to institutional and structural reform.
I agree with Bob, but let me make a slightly more optimistic take. I mean, I agree with Bobby. What he says is clearly right, but it's also possible, again, we won't know for a while, that on some issues there will be a desire for easy bipartisan wins if those issues can be found. And just this morning, the Senate Homeland Security and Governmental Affairs Committee, in a bipartisan vote, voted out of committee this really significant Inspector General reform. It's really the most consequential Inspector General reform in memory. And it kind of happened quietly. It happened because there's been and it goes actually to some of the issues that some of the sort of abuses that Trump committed, but it also goes to abuses that prior presidents had committed. So it was a process issue. It's kind of off the radar screen. It's actually very important. It's a very important piece of reform, and it seems to be moving along pretty remarkably. And it's possible that there are other issues like that where you can get some relatively easy wins. But on the other hand, Bob's general points are probably right.
So let's talk about Inspector General reform, because I do think, as you say, it's extremely important, and yet, for better or for worse, it's kind of flown under the radar. Maybe you could just walk us through, first up, why that's important, why it's something that people should be concerned about, the firing of inspectors general, that is, and what the reform proposal on the table is coming out of the Senate.
Yeah. So let me just first of all say that, the inspector general, the idea of the inspector general, which are these basically quasi-independent watchdogs inside of executive branch agencies, they started off being very controversial in the late 1970s, and they were politically controversial for a while. But they've actually, I think it's fair to say, in the last decade or so, become seen as more and more important to the functioning of government, and their role has come to be seen as more and more legitimate in terms of having an independent voice inside the executive branch to scrutinize what happened about certain matters and make it public. One data point on this is Attorney General Bill Barr 1.0 during the George Bush administration was exemplified the traditional unitary executive dislike of inspectors general and did everything he could to slap them down. Attorney General Barr 2.0 was much more friendly towards the Inspector General and actually complimented Inspector General Michael Horowitz in the Justice Department and talked more generally about the importance of inspectors general. So the Inspector General is not a perfect institution. There's always a danger that this quasi-independent watchdog will itself do things that are for which it's insufficiently accountable. But in general, these are very important institutions. President Trump, building on some practices of prior presidents, fired inspectors general, lots of them, which is the president's prerogative, and tried to fill the inspector general with people more congenial to the president's outlook, which defeats the whole purpose of the independence of the inspector general. And so one of the things, there are some very technical reforms in the Inspector General Act that just passed, but one of the central reforms is that it's very hard to stop a president from firing an inspector general, but you can deter the president's interest in doing so if you can keep the president from replacing the fired inspector general with someone congenial to the president's interests. That's what this reform tries to do by requiring the fired inspector general to be replaced with a career inspector general, someone who is almost certainly not a crony of the president. That's a very important reform. Bob and I explained at length in our book why we thought that was an important reform. And so that's actually quite a significant reform that goes to things that happened in the Trump presidency. It also has, I'll just mention briefly, other elements. It, for the first time, allows the Justice Department Inspector General to have jurisdiction over U.S. attorneys with a 5-year sunset. That's potentially very important. And it also gives the inspectors general across the landscape. This is also hugely important. Oh, I'm sorry. The power over U.S. attorneys does not have a sunset, but the power over, this is also very important, the power to issue subpoenas outside the executive branch is a significant enhancement of inspector general authority. That does have a 5-year sunset. So in general, the inspector general has been a very important office for executive branch accountability. It's done on the whole a great job, and these reforms are basically designed to ensure that it can keep doing that.
I want to also talk about emergency powers reforms, but before I do, Bob, is there anything you'd like to add there?
No, I think that's a complete account of where we are.
So then let's turn to emergency powers. Jack, you mentioned that there's been some movement on that as well. Again, I think it would be useful to sketch out why this is an issue of concern. What about the Trump administration led the two of you to think that this is something that needed reform, and then where it stands in Congress right now?
You want me to take that one, Bob?
Sure, please.
Yeah. So basically, the emergency powers process is broken. The original idea of emergency powers with reforms going back to the 70s was that the president has dozens and dozens and dozens of emergency powers provisions, authorities sprinkled around the US code that Congress has given the president. And the essential problem is that the presidents have invoked these authorities, declared emergencies in some situations where it's really not what we would think of as an emergency. And then more importantly, has continued those emergencies because the president can renew these emergency provisions, most of them every year. And the original conception of the National Emergencies Act in the 70s was that Congress could exercise a legislative veto to check that. But of course, Chadha eliminated the legislative veto. And so the reforms that were designed in the 70s designed to check the presidency have actually in some sense empowered the president's emergency powers. And I think it's fair to say that presidents of both parties have aggressively exercised and perhaps abused this power. Just to give you one example, the original emergency powers declaration going back to the 1970s that Jimmy Carter issued in the Iran hostage crisis is still in force and still being used as a basis for a variety of executive branch actions. Trump exercised emergency powers. There was a violent reaction to his exercise of emergency powers because of the political context and the border wall. But the truth is that if you extract away from that political context, this is not unlike what presidents have been doing for a while. And there was actually a proposal during the Trump administration by Senator Lee, Republican Senator Lee, to check these emergency powers basically by sunsetting them and putting a check on their time period and not allowing the president to have indefinite renewal. And there's bipartisan support. Senator Lee's proposals were basically included more or less in the Protecting Our Democracy Act, which was passed by the Democrats in the House. And I think it's fair to say from various statements and various bills that people have signed on to that there's general support for this type of reform to rein in these the kind of endless scope of these emergency powers. I want to add one more thing. There's a big exception in the bill that's emerging, and that is an exception for IEPA, the International Emergency Economic Powers Act. That's a big exception. That's the main provision that the president relies on. And so that's not a small exception to this process reform. But this process reform, which I think has a decent chance of getting through, is still very, very important.
So those are two areas of reform that it seems like there may actually be real prospects for moving forward on. But of course, you two wrote a whole book chock full of ideas for reforms that includes those two, Inspector General reform and emergency powers. But I can say, having read it, there's also a lot more in there. A number of the things you propose are in the Protecting Our Democracy Act, which, as you mentioned, has moved forward in the House, but I think it's fair to say faces a bit of an uncertain future in the Senate. So my question to you is, what are, other than emergency powers and Inspector General reform, what are the issues that are most important and that you think should really get top billing, given that Congress is not going to prioritize everything, both in terms of, everything's not going to be able to get bipartisan support, and of course, the clock is really ticking toward the midterms. Like what's at the very top of your list?
So let me just answer that in two parts, if I could. The first is that we do pay some attention in the book, and I want to highlight here, and it's also reflected on our website, that there are steps that the administration itself can take, if you will, self-regulation, that would help enormously here, particularly with the objective of depoliticizing the Department of Justice or protecting against politicization of the Department of Justice. And we sent a letter to Attorney General Garland on this issue, suggesting the ways, reflecting what we had written in the book, that the department could begin to reinvigorate some of the norms that have taken quite a battering in recent years through internal regulation, through the adoption of internal rules, and the affirmation of norms through the adoption of those rules. And that is still a course of action I think we would very much hope to see pursued. We have a president who's clearly open to it, made it very clear during the campaign how he thought about the Department of Justice, and I think he expressed that in part through the nomination of Merrick Garland. And so our view is that that's something that needs to be pursued inside the Department of Justice, and we hope that it can be. An example of that is, just to take one example, there's an informal understanding that the department doesn't take overt steps within 60 days of an election that could conceivably affect voter choice, but that needs to be revitalized by casting it into clear written terms as something that should guide the department's exercise of its prosecutorial discretion and its investigative judgments. That's one among a number of examples, including amending the ethics code that binds Department of Justice employees and contains strong counsel against allowing partisan considerations to affect the way they conduct their responsibilities. So I would stress that as being important. And we also believe that war powers, a tricky subject, something that it's hard to see advancing in the way I hope it might, we both hope it might, on the congressional agenda, at least in the near future, does involve some matters that the executive branch itself can address. So we've also written a letter in which we've urged the withdrawal of some opinions from the Bush era that are extraordinarily expansive in their description of presidential unilateral deployment of force, neither necessary to the resolution of issue at hand and not sound as a matter of principle. And so we urge that they be withdrawn. These are steps that can be taken, and we're going to continue to try very hard to urge that they be taken. And I'll pause there, but I will mention there are some steps that could be taken, you would think, that could draw bipartisan support: constraints on the president's exercise of the pardon power, clarification of the application of the obstruction of justice statute to the president. But I do fear, speaking of the results yesterday, I do fear that to the extent, as Jack points out, that anything appears to be a rehash of the complaints about Donald Trump in particular, that it's going to be much harder to have people focus on those issues on the merits rather than caught up in their, in the political implications that they may give rise to in some quarters.
Jack, I'm curious for your thoughts here too.
I don't have anything to add to what Bob said. I mean, the truth is, Quinta, as you say, we had a lot of reforms in our book. A good chunk of them were these Justice Department regulations. We haven't seen much yet from Attorney General Garland in terms of reforming lots of the kind of loopholes and problems that emerged during the Trump years, and problems that really should be made with the support of a Republican Justice Department. Should also want these reforms. They just basically clarify norms in ways that would have prevented some unfortunate practices, or at least checked some unfortunate practices. So a lot of the reform, but I do believe, I have no inside reason to think this, but I do believe that the Garland Justice Department is thinking about how it can buck up some of the internal norms that have been traditionally followed, and its weaknesses were shown. So that's very important. But frankly, on the congressional front, I just think for most of the other reforms, it looks pretty hard. I mean, it's possible that there would be reform of interference, foreign interference in an election. It is, again, possible that we could see congressional subpoena reform. That's another reform that basically fast tracks litigation of congressional subpoena authorities. That's another one that's received bipartisan support in the past. But the closer you get to, and again, war powers is conceivable, especially AUMF reform, but that's kind of been on the table for more than a decade now, and it's not clear what the way forward is on that. But some of the core reforms where Trump himself violated traditional norms, especially related to tax disclosure, conflict of interest, emoluments, pardon abuse. Again, there should, in theory, be bipartisan support for pardon abuse. That's been presidents of both parties have abused the pardon power at different times. But it's just not clear how the politics of that will work out in the next year, basically the window we have in the next year.
Could I just introduce one other thought here? I don't want to interrupt your sequence of questions, but I also want to mention a couple of items that I think ought to be on the congressional reform agenda that, for reasons having to do with the timing of our consideration of these issues and the timing of the publication of the book, Jack and I did not address in the book, but I think are important. Again, ones in which, or in connection with which one could easily say that bipartisan support might be expected simply because these reforms do not clearly advantage any given time one party over the other. One of them is reform of the Electoral Contact that addresses Congress's role in tallying in the final stages of the presidential selection process of the Electoral College votes. We saw, and we hear more and more every day, of how fragile that process could be. In fact, it's a old statute, poorly written, obscure, uncertain in certain cases in application. There's some extraordinary claims now being made about it that it seems to me need to be confronted head on. And then also transition reform. We also saw that there was some real question about how the Presidential Transition Act is in fact operating when a president, for example, refuses to concede an election. Wouldn't necessarily always be Donald Trump who refuses to concede an election, and the effect that has on the ability of the government, the new government, to prepare itself, whichever the government that turns out to be, but certainly the incoming, non-incumbent government preparing itself to accede to power. So I think those are two areas that really do require attention and that I think could be argued for on a bipartisan basis. The only other point I wanted to make was that the foreign national question, again, is very laden with all the arguments about Trump and the Russian investigation and so forth. And so it tends to be very provocative for a certain wing of the Republican Party. But yesterday, for example, in the last few days, it became clear, these issues are not going away. The Federal Election Commission, in an administrative ruling, held that foreign nationals can fund ballot initiatives intended to influence major public policies in this country. That is not prohibited by the Federal Election Campaign Act. So maybe we can start moving into that space a little bit without reference to specific issues that Republicans say are being unfairly somehow targeted at Donald Trump. And I think that's an opportunity we want to be able to seize to move that issue forward.
I'm glad you mentioned the Electoral Contact, because that was my next question. So great minds. And of course, I wanted to ask about the Electoral Contact because it does feel a little bit like the package of reforms that you proposed when the book came out became in a way kind of overshadowed by these questions about ensuring the integrity of the certification of the electoral vote, ensuring the integrity of the transition, even though, of course, all these reforms are necessary, I would argue, to protect democratic American institutions. So how do you understand the relationship between reforms that are protecting the integrity of the process of the American people choosing a leader and that leader being instated, and versus reforms to protect American democracy from that leader, if that makes sense? What's the relationship there in your minds?
Jack, do you want me to take a shot at this?
Please.
In any, I think, defensible, properly drawn statement of what constitutes democracy reform, you're looking at the various ways, and I apologize, something's just popped up on my screen and I need to get rid of it. There we go. Sorry about that. I do apologize for this. For some reason, something is interrupting. There we go. I got rid of it. I have no idea what it was, but it popped up. Maybe
No
speaking of foreign interference, I hope that's not the source. In any event, that the subversion of democracy, if you want to look at it, that challenges to our democratic institutions come in a variety of forms and at different points. One, of course, is through subversion of the electoral process itself, a situation in which a state simply refuses, for example, to certify the winner of an election, a certification that is widely believed to have been properly issued in accordance with the laws of the state, and politicians of the state legislature insist that it was illegitimate and wish to send their own electoral slate to Washington. And then you can imagine precisely what some supporting Donald Trump and the president himself imagined he might be able to do, and then have some collaboration between state legislatures acting in that fashion and the president of the Senate to simply refuse to accept the state certified results and replace them with these other results generated through the state legislature. That's one form of democracy subversion. But then again, there's democracy subversion on the other end, where we have where our governing institutions themselves become politicized. They become weapons. They become a means by which one party, once it has acquired power, maintains it. And that goes to a whole set of questions that people have about, of course, the Department of Justice, the topic we were just discussing. What happens when the Department of Justice becomes perceived to be one of the spoils that the winners of an election acquire, and they can be turned to their political advantage? Both of those, in different ways at different times through different processes, challenge fundamental notions that we have of what it means to live in a democracy.
Jack, any final thoughts before we go to the next panel?
Nope, I concur.
All right. Well, Bob and Jack, thank you so much. I will conjure you back on stage in about 30 minutes. And in the meantime, if you wouldn't mind turning your cameras off, and if the other panelists wouldn't mind turning theirs on. Thank you, everyone. So let's just start off by giving you all an opportunity to reflect on the conversation we just had. What do you think that the landscape looks like right now from reform of presidential power? Which reforms do you think are most important? And what would you like to see Congress and the Justice Department focus on? Kelsi, let's start with you.
There we go. Sorry, I was having trouble with my mute button there. So I found that conversation really interesting. I read Jack and Bob's book last winter, and it was illuminating in so many respects. But what stuck with me most was their framework of distinguishing between President Trump's violations of laws from his violations of norms. So, and this came through in their discussion just now, how much of our democratic foundation is not tethered to law, not just with respect to the executive branch, but also Congress and the judiciary, which is where I spend most of my time as a litigator. And, you know, as Bob and Jack, I think we're saying, you know, discretion is to a certain extent a necessary feature of the independence of each branch. And so as a former Justice Department attorney, I've been watching particularly carefully how the Garland Justice Department has been exercising its discretion and balancing its traditional commitment to defending executive power with its role in responding to the Trump administration's abuse of power. So Jack and Bob were speaking quite a bit about rulemaking and policy reform within the agency. Another lever the department has is its litigating positions. I was in the civil division during the transition from the Bush administration to the Obama administration, and it struck me at that time how little changed with respect to the department's litigation defense of executive power, whether it was in resisting subpoenas, asserting immunities, and so on. That institutional interest in a robust executive has persisted across administrations and political parties. And so what I think we have seen under the Biden administration is a Justice Department that is acutely self-aware of the tension between the institutional interest in defending executive power, as it usually does, and then also its responsibility to respond to the unprecedented abuse of power by the Trump administration. I think generally it has been adhering to the former. So you have, for example, the department's decision to defend President Trump against the defamation suit by Jean Carroll. I think Attorney General Garland at one point described that decision as flowing from the department's responsibility to protect the executive branch as an institution, regardless of who's in power. There's also the department's defense of President Trump and Attorney General Barr in the lawsuits arising out of the government's attacks during the Lafayette Square protesters. There's the department's resistance to releasing the OLC memo on whether to charge President Trump with obstruction of justice. And so, you know, the irony here, I think, is as frustrating as these decisions have been to many people, they're consistent with the norms that have traditionally guided the department and its institutional role in defending executive power, particularly with respect to civil litigation. And so the rebuttal there is that the norm should be abandoned in response to the Trump administration's unprecedented abandonment of norms, but there's a cost there. I think these are really difficult decisions. I don't envy Attorney General Garland in having to sort through them.
Absolutely. I think that it's a tough nut to crack, however you do it. Mary, let me turn to you next, and then I'd love to get Alan's thoughts.
Yeah, I agree with Kelsi's points. I also very much, agree with everything we heard from Jack and Bob in terms of reforms that are needed and sort of priority issues, but also on their assessment of what is likely to be able to be accomplished out of Congress right now. And I think it was challenging before yesterday's elections. I think it's going to be even more challenging going forward because we have a situation where we're coming into, we're going to be coming into midterms. Already, I feel like we're coming into midterms, and what just happened in Virginia and elsewhere is going to have an impact on that. And even though everything has already become a political issue, things that should have bipartisan support have been pigeonholed into sort of an us versus them type of mentality. I think right now there's going to be a lot of assessments of how any positions on any reforms might impact the midterms. And I think that's going to be significant to getting anything accomplished on Capitol Hill. That doesn't mean things can't be accomplished. I think Bob was alluding to this, and maybe Jack as well, within the Justice Department, within the Biden administration. And I mean, we certainly had Merrick Garland at his confirmation hearing talking about how he, will not be the president's lawyer. He aspires to bring back that independence of the Justice Department. He did in July, put out guidance, a directive that is not hugely different from what has been in the past. It's a limitation on contacts between Department of Justice lawyers and the White House, a limitation on contacts, particularly with respect to investigations, criminal investigations, civil investigations. There are always exceptions to that. For example, in national security, and I was, of course, in national security at DOJ for several years. There are always other reasons that discussions of national security investigations might need to involve the interagency because they impact foreign policy and other things like that. But it is a strong reassertion of that independence, and included a provision for Justice Department employees to report up if they are contacted by someone in the White House about taking a particular position or doing something with respect to an individual investigation, and that is important. I think there are more things that DOJ can do within its own authorities and those are outlined in the Presidential Reform Project letter that Jack mentioned. Having spent 23 years at the Department of Justice, it doesn't operate, turn on a dime. And so I expect that these are all things that are very much being considered. And I'm sure that Attorney General Garland wants to get the advice of career attorneys on many of these issues, as well as appointees, and not all of the appointees are even, I think, in place. So I think that we will see more coming there. And I think that is an area where there's more that still could be done. Last thing I'll say is, in terms of just the executive branch sort of writ large beyond the Department of Justice, is we did have, when President Biden first took office, he did put out an executive order that required an ethics pledge by political appointees, senior officials, and this included restrictions on lobbying type activity, revolving door activity, both coming into government and going back out of government. And, these were some of the strictest, I think, that we've seen. And that's a great start. But there is more that certainly that the president promised during his campaign that of things that are within his power through executive orders, et cetera, that I think, there's still plenty of room to go there for the administration taking action toward some of those reforms.
Alan, let me turn to you. What are your thoughts?
Well, first, let me thank you, Quinta, for moderating the discussion, as well as Bob Bauer and Jack Goldsmith and the Presidential Reform Project and Georgetown's Institute for Constitutional Advocacy and Protection for doing this with checks and balances. As you noted, Quinta, I'm a founding member of that group. And for those who don't know, it's a group that was established in 2017 as comprised of conservative and libertarian lawyers, many of whom served in prior Republican administrations, with an emphasis on supporting rule of law principles and doing so regardless of the person or party in office, in power. So thanks everybody for convening this great discussion and for including me in it. I'll just start out on a note on some optimistic points, which I think are few and fair between, but let's accentuate the positive. I think one possible implication of yesterday's electoral outcome is that neither party can really be confident that it will be in power in a year or in 3 years from now. So perhaps there's a sense of being in a kind of a state of nature here, where maybe there's some reforms that are possible because neither party knows, who will benefit from the reforms going forward, and therefore maybe there'll be an interest in doing what's best for the country, since we don't know what's best for a particular party or individuals. The second note of optimism would be, as Jack Goldsmith noted, there are some pockets of reform going on, and I think, Quinta, you characterized it as perhaps reforms that are occurring under the table. So to the extent that the issues at hand are not they're not occurring in the broad light of day, and therefore perhaps more likely to become polarized and controversial, perhaps this is an opportunity for reform. But I do want to pick up on something that Bob Bauer said regarding the president's ability to take some of his own steps, in the case of President Biden here, and in particular to promote certain norms that are consistent with the type of reforms we'd like to see for the benefit of the country and the benefits of governance. While legislative and procedural amendments and reforms can be critical, many of the most necessary changes that would be perhaps most beneficial are cultural and civic and relate to our norms in favor of constitutional principles and rule of law traditions and values. And what we're seeing, I think, as a principal problem faced by the nation is cynicism. And I think the president and his bully pulpit and some of the key officials like Merrick Garland are well situated to promote the concepts of cynicism bad, democracy good, and to help reinforce our institutions, confidence, justifiable confidence, hopefully, in our institutions. Some of the combating of cynicism that I would submit is necessary is for the presidents and leaders of both parties to model restraint in possible transgressions against the rule of law, and not to assert policy positions, legal positions, just because it's worth trying them. So what does that mean in practice? Well, if the concept would be the policy ends don't justify the unconstitutional or extra lawful means. So no more Biden pushing CDC eviction moratoria that he says he knows are unlawful. No more Trump claiming border walls can be funded from military crisis funds that really don't apply. And no more Obama acting in his own assessment like an emperor by implementing immigration deportation policies that Congress didn't enact. So the president, the presidency, the current president, future presidents need to restrain themselves and not pushing the legal envelope, because that just promotes cynicism. It reduces faith in our institutions. Congress has got to play ball on this too, and the president needs to use his power, his bully pulpit, to really hold Congress accountable for governing and not just obstructing, and both parties. So Jack Goldsmith mentioned reforms on the subpoena power. It's another way of saying really that Congress has got to take its responsibility seriously. And the president has got to, under the separation of powers and comity for a coordinate branch, co-equal branch, has got to respect congressional subpoenas, again, within the bounds of the constitutional separation of powers. But the president needs to hold Congress accountable to performing its responsibilities to the American public. So I started out on some optimistic notes, I hope, holding Congress accountable to governance and holding presidents accountable to self-restraint. Maybe that brings it back to reality and maybe departs a little bit from the optimistic notes. But that's where I see reforms as necessary and hopefully possible.
Mm-hmm. So let's talk a little bit more about Congress, because I think that the fact that we're having this discussion about reforms of executive power, well, of course, the January 6th Select Committee is continuing its investigation, makes for a kind of an interesting parallel story where there, of course, we're seeing Congress perhaps attempt to assert its own power and its own authority in investigating an attack on the Article 1 branch of government. And I think there are a number of different angles that we can touch on here. But Mary, I wanted to turn to you first. Attendees of our event might have seen that the news broke this morning that Mary is representing the committee in some of the litigation over the committee's efforts to get access to Trump administration records from the National Archives. I won't ask you anything specific about the litigation, but in broad strokes, could you speak a little to maybe how you're thinking about congressional assertions of power, the ability of Congress to get information from the executive branch? We saw that was a big problem under the Trump administration. How does that fit in with the conversation we're having right now about reforms to executive power?
Yeah, thanks, Quinta. And just to clarify, the Office of General Counsel is, of course, of the House of Representatives is of course, the lead counsel in this current litigation, but ICAP attorneys are also involved as co-counsel. We've co-counseled with the House Office of General Counsel in previous cases, including cases involving congressional subpoenas, for example, of Don McGahn during the last administration, and also the request for Rule 6E material, grand jury record material as part of the Mueller investigations report, because that was redacted from the Mueller investigation report. So these do involve, like you say, efforts by Congress to, exercise its core Article 1 functions, its legislative functions. And in some cases, there were also functions related to impeachment, which are, of course, no longer on the table. President Trump is no longer president. But those core functions have been, in many cases, thwarted through a variety of different litigation means that do suggest the need for reforms when it comes to congressional subpoenas. I think in the bill that it has been passed, that was discussed earlier, Protecting Our Democracy Act, there are some congressional subpoena reforms about enforcement of those subpoenas, fast-tracking those subpoenas, because what we've seen, particularly with respect to the House, which is just a 2-year body, is it can, litigation can simply time out it can extend beyond the life of any particular House of Representatives. And that means that, ultimately Congress gets thwarted in its ability to carry out its constitutional responsibilities. And certainly with respect to the current investigation by the Select Committee on January 6th, we were talking about requests under the Presidential Records Act of 4 documents, presidential records that are in the care and custody by law of the archivist of the United States. And so these are executive branch documents. And of course, President Trump has asserted executive privilege over those, and President Biden has declined, at least with respect to some documents, to agree to assert executive privilege. And so that is the basis for Trump now having brought litigation to prevent the archivist from transmitting to Congress these documents. And so, just to go back to your very first question, we are talking about an investigation into an attack on Congress itself. Congress, who was empowered on January 6th by the Electoral Count Act to actually open up and count the votes submitted by the electoral slates from each of the states and certify that vote. And so, I think this really points up the need for reforms, because when we are looking at what Congress is attempting to do there, to be able to investigate, and courts have always said Congress must be able to investigate in aid of its legislative authority. It needs to be able to investigate in order to undertake its, important tasks, much legislation of which might be executive reform legislation. So I think these things do fit together. I think it's always important when we're talking about the different branches the separation of powers that is the core feature of our Constitution. It requires not only, it's not complete. There is overlap there. And historically, the branches have, I would say, based on norms, have, even when they would sometimes fight against each other, they would often find ways to accommodate, because there's, I think, an appreciation by each of the branches that for our system to survive, there has to be some accommodation. And what we saw in the last administration, I think, was the violation of the norm there was really that failure to try to work toward accommodations when you did have interest by, Article 1 powers, Article 2 powers. Article 3 plays in a little bit differently, but of course that's calling on the power of the judiciary to resolve litigation that might arise. And that had some very unfortunate consequences when it came to thwarting one branch from actually being able to exercise its constitutional authority. So I think that's an important piece of any reforms going forward.
Kelsi, I also wanted to turn to you here and go back to the really interesting point you made at the beginning about how the Justice Department is positioning itself here. On the one hand, you can look at how the department has responded to requests from the committee and say, well, they're playing ball. President Biden has declined to assert privilege over a wide swath of documents. There are also instances where the department has given the okay to former senior officials, including the acting attorney general under Trump and his deputy, to testify before Senate panels. On the other hand, I know there's also some discontent out there from maybe people on the left, Democrats, saying that, Attorney General Garland should have already, got ahead with, say, prosecuting Steve Bannon for contempt for refusing to engage with the committee. What's your sense of how the Justice Department is positioning itself here? Is it striking the right balance between, sort of as you phrased it earlier, the need within the department to maintain a sort of traditional executive institutional power and the need to acknowledge the norm breaking that happened under Trump, or is it falling on one side or the other?
This is such a hard question. Again, I'm almost I'm glad I'm not the one who has to make these decisions, and I think it's often not one big decision. It's a bunch of micro decisions, right? At every step in the litigation, obviously, when we're talking about subpoenas, the Justice Department has particular clients it needs to be representing, and even when you're talking about the one that's been most difficult for me has been the Lafayette Square protest. Like many people, I watched what happened that day with horror as the government was attacking the protesters. But for better or worse, the government's or the Justice Department's defense of the federal defendants is consistent with deeply entrenched norms. And so I think it would have been difficult for the Justice Department it would have been unprecedented for the Justice Department to have refused to defend there. On the other hand, there are a lot of levers within that kind of broader decision, right? It has the authority to settle, it has the authority to decide which defenses it's going to raise. And so I see a Justice Department that's has been reluctant to break from those norms, and going back to the principle that Jack and Bob often articulate, which is we need rules and norms and policies that apply equally, that aren't designed to favor one party over another. What the Justice Department is doing has been consistent kind of with what it's always done, and presumably will always do. I will say one thing that the Justice Department has done that is unprecedented is the challenge to the Texas heartbeat law. And as the Solicitor General said on Monday during the argument before the Supreme Court, the reason that the Justice Department has taken that unprecedented step in asserting executive power against a state is because what Texas has done is so unprecedented, right? We don't have any historical examples of a state attempting to flout federal, both the judicial review piece of it and at the same time, the supremacy clause and executive power. So I think that's a place where the Justice Department's or this administration's policy interests aligned with its interest in asserting executive power.
For our last few minutes, Ellen, I wanted to return to you and also touch on a point you made at the beginning, where maybe the fact that these issues are getting less attention than we might want them to get could, in a sort of backwards way, be a good thing. Which maybe is an argument against holding this panel, but all of our attendees should just be very quiet about what they've heard here. In all seriousness, I do think that, you can see how these conversations, when they become politically salient, become more difficult. For example, President Biden saying that he feels that the Justice Department should prosecute Steve Bannon for contempt, which the department then pushed back on, which I was certainly glad to see, but it makes that more difficult. Is it a good thing, as you were suggesting, that these conversations, if they happen quietly, if they happen away from the spotlight, is that something that you think we should expect to see more of and encourage?
Well, we should definitely encourage it, Quinta, that there should be an effort to rebuild institutions through direct conversations by people in office, by members of Congress, informal conversations where the consensus that many people in both parties share, that there are norms that ought to be respected so that our democracy endures, that it survives, that it flourishes, and that is strengthened when it's under assault. By the same token, unless there is public discussion to reinforce these objectives, it's not going to bring the country around. The country has to see some of this activity and see that members of both parties kind of come together in support of common principles that are essential to the foundation of our system, to our democracy. The executive privilege issue, former President Trump's claims of executive privilege, which have been rejected or largely rejected by President Biden, really does provide an opportunity to ensure that Congress gets the documents it needs, and does so in a manner that would be true in the case of either party. So yesterday, certain members of Checks and Balances issued a statement in support of President Biden's waiver of executive privilege and for the documents claimed to be privileged by President Trump, and that it needs to be, as Mary was indicating, resolved quickly, because otherwise this can get tied up in litigation, and really it becomes essentially moot, and the public again sees chaos rather than reasonable disposition of these issues. So the fact of the matter is that the Supreme Court has recognized presidents of all parties have claimed executive privilege because the president is entitled to get the benefit of confidential deliberations. And that's not for the president's personal benefit, but for the country's benefit, so that the president can be effective in executing actions, under the law. So the question of a former president's claim of privilege for what he would assert are his confidential discussions and deliberations really ought to be viewed through a prism that can apply to either a party. Here, the incumbent president, as the Supreme Court said 40 years ago in the Nixon versus GSA case, only the current incumbent president can take action under the Constitution. I mean, that goes without saying. But they recognized 40 years ago that conceivably there could be a claim by a former president that the current president may wish to consider, because what's kind of sauce for the goose is sauce for the gander, and what comes around goes around. But here we've got a situation where the claim of executive privilege is not for official duties or conduct in discharge of constitutional authorities or obligations. We've really got a claim of privilege over political acts, a desire to shield political acts and possibly personal liability for political acts. And so the claim is really fatally weak, even though departments of justices in both parties and lawyers in White House counsel's office from both parties would respect executive privilege, but there are principal distinctions of why the claim by a former president here should be rejected, and it has nothing really to do with the party. So I think it is important to come back to your question, that the public understand that there are principles behind the decisions that are made, and that prosecutions and claims of privilege or rejections of privilege are grounded in the Constitution and the fair administration of justice. And if the public doesn't see those conversations, that discussion, they won't understand it. And each side will just conclude that, oh, it's just business as usual, both sides acting in their partisan self-interest. So it's important to explain that there is a principled basis for what the Department of Justice is doing, what the president is doing, and Congress.
Thank you. All right, we've reached our last 15 minutes, so I'm going to ask Bob and Jack to return to our virtual stage. Thanks to you both. So before we start in, Bob and Jack, I'm curious if you had any thoughts on what we just discussed, particularly the relationship between the January 6th committee investigation and the reforms that you discussed, since that wasn't something we were able to touch on in our first discussion.
We do address the question of congressional subpoena enforcement in the book, and support a remedy here, recognizing some of the complications, and also in our book suggesting that there are some aspects of the proposed reforms in that area that we have concerns about, threat of fines of recalcitrant officials and that sort of thing, which we're not sure is all that terribly helpful in the debate. But certainly, all I have to say to that is that I do think this has to be on the reform agenda. And I understand there are some tricky questions. Each administration has to approach it with some concern about what may happen around the corner when the opposition party, if it does, takes power and abuses the investigative process on the Hill. But it is a matter that we do address in the book. The one thing I did want to mention about norms that crossed my mind, and I don't want to retrace steps we've already covered, so I'll be really brief about this, is one of the real challenges in a highly polarized polity, something that Jack and I have discussed quite a bit, is that norms that we would take for granted are put under tremendous stress when people view the issues at stake in the political process to be existential. Norms are honored when they seem to uphold institutional arrangements that people believe are fair and that are producing outcomes that they can live with, even if they lose some and they win some. When the view is that that isn't the case, then invoking a norm as a reason why a particular action can't be taken, say by the Department of Justice, by the executive or whatever, on existential issues is going to run into some significant resistance. And we've seen this in recent years on both sides. And so I'm not speaking for Jack here, I'm speaking for myself. I think there are some assumptions we make about the vitality of norms that under contemporary political conditions just may not hold to the extent that we would like to believe that they do. And I'm not saying that's a good thing, I'm thinking it's a regrettable thing, but I want to make that point.
Jack, any thoughts?
Just one quick thought. Bob is clearly right, and the other commentators are clearly right. One of the aims of a lot of our reforms is precisely to deal with the problems of stress on norms in a time of political contestation and splintering. And the hope is, sometimes often I would say norm violations are in the eye of the beholder. And that's why compliance with norms when there's massive political contestation, and when, for example, many things that the Justice Department does is seen through a political lens, it just makes it harder to see examples of norm compliance and norm violation and to have consensus on those matters. For reasons that we go to at length in the book, we think that a lot of the reforms we propose they're actually in some ways designed precisely for a situation to help both control the consequences when you have a president, for example, who is urging DOJ to do certain things in violation of norms. If there are certain processes and norms in place in the department that might both give the department more leverage to resist the president, and when it acts, it can also make what it does seem less political if it's seen to be tied to a specific concrete norm. So that's a little bit complicated, but The bottom line is in an area of enormous political contestation, when everything that's done in Washington is seen through a political lens, and especially the Justice Department and the White House, especially the Justice Department, is seen through a political lens. These issues are extremely, extremely difficult, but they're also one of the things that we're trying to help with, one of the things that we're hoping to make progress on.
I think that goes back to Alan's earlier point about cynicism in an interesting way, where, if we as a nation sort of accept culturally and politically the idea that there are norms, and that people in government are taking them seriously, then perhaps people will be less likely to see, every decision as politicized. Whereas if you take the view that I think President Trump often voiced, that, everybody is just out for themselves, everybody has fixers, that the Justice Department has never operated on the basis of norms, it becomes much easier to see everything as politicized. And indeed, I think that's how we saw President Trump acted and seemed to feel that others acted wrongly, I would argue.
Yeah, I agree.
Just again, to stress one thing, it's, from my point of view, the threat is not just that the issues are going to be viewed through a political lens, but they're going to be viewed as a political lens in something like an emergency setting. For norms to function, people have to be willing to lose. And if losing is unimaginable, right? If what you're trying to achieve is not achievable through normal means, and that's not an acceptable outcome, then the norms are going to be discarded, and end runs around the norms or absolute defiance of the norms is more likely to occur. And so I just want to emphasize it's the political lens coupled with the view that losing is unimaginable because the stakes are existential. That seems to me is a huge threat to the ability to defend and present norms in a polarized polity.
But I'll just add that it's very hard through the types of reforms we're talking about to make these matters not seem existential. That's a different process. That's a different set of dynamics. That's what we're dealing with. That's the reality. And I think Bob is absolutely right. That's one of the serious challenges here.
So let me turn to the other panelists for their thoughts on this. If we're talking about these very important reforms that, are going on, we have this problem of sort of politics in an emergency and a sense of decaying norms. Are we, rearranging deck chairs in the Titanic, so to speak? Mary, I'll hit you with that very difficult question first.
Well, I don't know if this is going to address your question, but particularly listening to what Jack and Bob were just saying, I think one of the things that also makes things so challenging is that we live in an age of social media and cable news and disinformation, so that I wonder how much, the outside the Beltway people care about norms, because so many people in this country are consuming their news from sources that are not respecting the value of norms and are politicizing them themselves. And I'm not even pointing fingers at one side or the other. It's just, news has become entertainment, and entertainment, always looks for conflict because conflict gets more viewership, and social media algorithms, promote conflict in terms of providing material to people. And I think the impact of this has driven, it's really back to Alan's cynicism point too, I think, right? The public is so cynical about government. I think there's a failure to respect politicians of either party or believe that they are complying with norms for some of the reasons that Bob indicated, because everything's existential and there's not a willingness to lose in order to uphold those norms. And so I don't have an answer for this. It's just, it adds to the challenge in the moment. And I think that's partly why we don't see a lot of attention being paid to these excellent recommendations for reforms, because that's just not the way our people are gathering their news right now. And the disinformation is what is carrying the day. I mean, even if to go back to last night's election, when apparently the lead issue for a number of people in Virginia was whether, critical race theory was going to be taught in in the schools in Virginia. And that just seems like, given what's happening in the country today, that's kind of a shocking thing to be so important to people that it would drive a particular election. So I'll leave it at that.
All right, I'm going to turn to Kelsi, and then Alan, I'll give you the last word.
Yeah, I ask myself that rearranging deck chairs question all the time, because I think, we're certainly divided as a country into Republicans, Democrats, right, left, but there's also an increasing divide that maybe comes out the most in social media between kind of institutionalists and activists. My day job is Supreme Court litigation, and so I think I see it most often in the debate over Supreme Court reform. I was on the Supreme Court practitioners subcommittee of the commission that Bob has been leading. And as we considered a number of the kind of policy suggestions there, over and over again, this bipartisan committee had the reaction, well, that's a violation of how we've designed our institutions. It's a violation of separation of power, of the independence of the judiciary. And I think you see those same debates going on with respect to Congress and with respect to the executive as well. So as a litigator, I've put my faith in institutions and the ability of the courts to remedy the wrongs. And I think what Jack and Bob and Alan have been doing is really, really important work, and kind of trying to restore faith in our institutions, and kind of looking back at history and how we're going to maintain what we have. But time will tell. As we've discussed a lot today, the clock is ticking. We have another set of elections coming up next year, and whether all of this work is leading to anything, it's certainly noble. I think we'll have to wait and see what history, how it plays out, whether it was rearranging deck chairs or not.
So, as Jack noted, it's difficult to see the issues under discussion as other than existential. But as Bob noted, if either side sees the stakes as existential, then you can't really afford to lose. So if we can change the conversation so that what the existential threat is the future of our democracy, maybe both sides can get behind that in some way. So back in 1787, coming out of Independence Hall after the Constitution was approved, Ben Franklin was asked, what sort of a government did you create? And he said, a republic if you can keep it. So I think what we're talking about is how to keep the republic. So at the risk of being dismissed as naive or Pollyanna, I think that President Biden, any next president, should make a central part of his or her agenda to communicate and advocate for democratic ideals and the rule of law. I mean, that seems obvious, but I submit it's not so obvious. So a closing thought is, how do you do it? Is make like Ronald Reagan in 1982, when in his speech to the British Parliament, known as the Westminster Address, he was looking at the existential threat at sort of as the Cold War was at its height and approaching, didn't come to its end until the end of that decade. So he gave a speech to Parliament in which, he talked about the importance of building the infrastructure of democracy around the world to foster, democracy, free press, unions, political parties, universities. I think today we need to foster that infrastructure at home and see whether we can help unite the parties and somewhat ameliorate the polarization and the tensions that have made people so divided by coming back to first principles. So if that's Pollyannish, so be it. I think the president has got to be out there as a spokesperson for first principles. Hopefully we can agree on what's obvious, which is that the Constitution is important preserving and advocating for.
I think that's a very appropriate ending to this conversation. Thank you, everyone, for joining. It was a great discussion.
Thank you, everybody.